You've used your defensive tools for a life-saving encounter. Now what? Hi, everybody. I'm John McLaughlin, chairman of the Iowa Firearms Coalition. And as many of you know, about a year ago, we started a program with Firearms Legal Protection to offer IFC members an opportunity to have a legal defense should that rare day actually happen in your life. So joining us from Colorado right now is an FLP attorney, James Cook. And James, first of all, thanks for joining us. And just kind of give us a little bit of background about yourself, then we'll jump into what folks should do if they ever have to, spray someone in the face with OC or, heaven forbid, actually have to use their firearm.
Well, thanks, John. My name is James Cook. I'm Colorado's lead attorney for FLP. I started my career with the 4th Judicial District Attorney's Office here in Colorado Springs. Started doing minor traffic offenses, misdemeanors, those sort of things. I went and took over all the prosecutions for Teller County for a year, and then came back to the Springs and started doing more major felony cases. In 2013, I saw the way that our state legislature was going with the anti-gun laws they were looking to pass. I decided it was my time to get out of the DA's office and move into private practice, where I could start advocating for the rights of gun owners and people who have been wrongfully accused of crimes. So I've been in private practice since 2013. I also own a gun store. My dad's a gunsmith. He's since retired. I've taken over the business, running the business at least. So I've got my federal firearms license. I deal a lot with NFA compliance and those sort of things, silencers, short barrel rifles, machine guns, help people get the really cool stuff. And I do a lot of criminal defense cases, specifically focusing on firearms.
Well, maybe we should do another episode soon on all the stuff that's going on now with the braces. But for today, we'll concentrate on, let's just give you a scenario and let you run with it. So someone has to use their firearm. They feel they've done so lawfully, legally. They were truly in fear for their life or the safety of those around them. And what I have found, at least in the past, maybe not so much right now, but generally law-abiding citizens are pro-law enforcement. They're pro-police. They want to tell their story. They want, I did everything right. Whatever I was trained, I did, thinking that the police are going to be like, rah, 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 good job by you. But I know in some cases that's just not the case. So what does, FLP, and particularly you as a skilled defense attorney, tell people they should do? How should we handle this very stressful encounter where, after the fact, folks may have cloudy vision or not really thinking quite straight?
Well, what a lot of people don't understand is that just because you feel something at the scene of a crime or of an alleged crime, I shot this person and I believe that I was in imminent fear of death or serious bodily injury. Therefore, I acted in self-defense. Well, right. Great. That's certainly going to be our defense going forward to trial. But understand that it's the decision of law enforcement, it's the decision of the district attorney's office, whether or not they're going to file charges and whether they're going to go forward with that. So just because you felt that at the scene doesn't mean they're going to agree with you. Doesn't mean they're going to look at this and they're going to say, yep, we think that this is a good shoot. We're not going to file any charges and we're simply going to let this go. And where a lot of people get themselves into trouble is they think that legally I'm going to be good to go. Mm-hmm. And they start shooting their mouth off and they say everything to law enforcement and they wind up digging their own hole. I've seen that in plenty of my own cases. Right. I can't tell you the number of people that have said, I wish you would just shut up when you were talking to the cops, because then you wouldn't have had to have hired me. Right. The truth is that in the moments after using some kind of force, deadly force or less than deadly amount of force, you are going to be under the effects of adrenaline dump. The best analogy I can come up with that most people have had experience with is if you've ever been in a car accident. Think of the feeling that you have when you get out of the car, the moments afterwards. You're kind of shaky. You're a little bit nervous. You're maybe not thinking very clearly. Think of how well you could describe that car accident a minute after you got into it. Then think about how well you could describe it a couple of days afterwards, when you've had some time to calm down, to think through it, when you've had people ask you questions about what happened. You were able to sit down calmly and think about it so you could answer correctly. Here's what was happening. Here's how fast I was going. Here's where this person was. The problem is a lot of people get into answering questions immediately after something happened, and they're not thinking clearly because they're under the effects of that adrenaline dump, and it winds up making their case much, much more difficult for them.
So what is the proper answer? Just tell the police, hey, I'm willing to cooperate, but I need an attorney and some time to calm down? Or what are the words that, should be trained just like our firearms training into our mind if we ever have to, face that day?
Yeah. So there, you have a Sixth Amendment right not to speak to law enforcement without an attorney present. And I definitely advise people, do not speak to law enforcement without having that attorney present. My job is to get you, not necessarily to help you, coach you, to help you think of a better way to make this incident sound. Is primarily to get you calmed down, so we can go over the situation. I can ask you questions that I know are going to come up, so we can think about the answers together and you can answer them clearly. And the hardest part that people have is just saying, I don't know. Because oftentimes if somebody asks you a question, you don't know the answer, you're going to make up an answer. I've seen it happen with so many of my clients. And when you start making up answers, it might be true, it may not be true. And if it's not true, that's where we get into trouble. So when you have used some kind of force, law enforcement wants to question you about it. My answer to that is you need to ask for your attorney. The Supreme Court has said there isn't a specific way that you have to ask for your attorney. There's no magic words that you have to give. My answer is, officer, I'm not going to make any statement until I have an attorney present to, be with me during counseling. Great. Okay. That sounds nice and wonderful. But the idea that after you've just shot somebody that was trying to kill you, you believe that you are in imminent danger of death and serious bodily injury, you're going to be able to say that really calmly? It's not going to happen. What I tell people is just ask for a lawyer. All right. If you are curled up in the fetal position on the ground screaming, I want a lawyer, I want a lawyer, I want a lawyer, law enforcement is going to get that. And they are not going to be able to question you without having that attorney present. If you just say, I want to, remain silent, great. They can't question you at that point until they've waited a reasonable amount of time. What's a reasonable amount of time? It's whatever the cop thinks he can sell to a judge in court. It could be 5 minutes. It could be 5 hours. It could be, who knows? All right. But if you ask for an attorney, legally, they have to make some effort to get you an attorney before they attempt to question you. And that is far more valuable than simply just delaying and saying, I don't want to talk right now. So ask for an attorney. There's no magic words, but you have to get across to an attorney before I answer any questions.
So that's where FLP and some of the other programs that are out there come in. You have a number to call, instant access to some legal advice. They'll get somebody there, at least, in pretty short order. It may not be yourself, right off the bat, but somebody to fill in that gap. Is that typically how that works?
Yeah, and what I tell people is I teach a lot of classes in person, and in my classes in person, I will let everybody know, hey, I've got business cards. I'd be happy to give you my business card. And if you take my business card, you look on that, it's actually got my personal cell phone number on there. And if you call my personal cell phone number at 2:30 in the morning on a Saturday, I am not going to answer that call because I've had too many clients that have abused that privilege in the past. Sure. But if you call up the FLP hotline, all right, there are 3 numbers that can get through to my cell phone at 2:30 in the morning on the Saturday: my parents, my wife, and Firearms Legal Protection. And you are going to actually be able to get an attorney at the time that you need most to be able to speak to an attorney when you call FLP. And that is absolutely invaluable. It is not something you're going to get from, knowing the attorney down the street or, giving somebody a retainer that you met in an office one time. Right. Something you're only going to be able to get from a program like FLP.
So one of the fears I hear to talking to people who have actually been in these encounters is I started talking to the police because I thought I was going to have to sit overnight in jail while this got sorted out. There is a strong possibility you may get pulled in and sit overnight, but should that be something to fear to just start spilling out information?
So law enforcement's job is to investigate a crime. It's ultimately the district attorney's office's job to decide what charges are going to be filed, how they're going to proceed with filing those charges. But this is kind of a counterintuitive here. People want law enforcement to do their job. You want the cops to go out and investigate crimes. Right. And when you have got a dead body on the ground and you've got a warm gun in somebody's hand, you want them to do their due diligence and investigate this to determine whether or not a crime has occurred. So yes, if you have actually pulled the trigger on a firearm, you have actually shot another person, you are going to be detained. It is not going to be a situation where, because it's your own house, because this person has a face tattoo and a criminal history, that law enforcement is just going to walk in there, high five you, and say, "Good shooting. Thank you for saving us some paperwork." You've created a mountain of paperwork for them either way. Talking to them isn't going to alleviate that. So, are you going to be custodially interrogated? Yeah. Are you going to be detained? Are you going to be brought down to the police station? Absolutely, you are. If you shot a person, if we're talking about a home invasion situation, you shot a person inside your house. Most of what you see on TV shows like CSI is complete make believe, but some of it is real. They are going to go in there with those lasers that figure out a bullet trajectory through the house and that kind of stuff. You're going to be out of your house for a few days while CSI does their job. They're going to investigate this fully. So yes, it is going to be extremely uncomfortable for you. But the thing to remember is the reason you are using deadly force is because the consequences of not using deadly force are worse than the consequences of using deadly force. You had to shoot somebody to save a life, to protect a life. So it is going to be uncomfortable for you. There's no way around that. And opening your mouth and talking to them, thinking that I'm going to be able to talk my way out of this faster if I speak to somebody without talking to an attorney, is absolutely wrong. It's not going to get you out of detention at the local police station any faster, and it can very easily wind up with a case that was going to not be filed turning into now a case that is going to be filed, and instead of spending a couple of days at the station waiting for them to decide if they're going to charge you with anything, you're now going to be spending months to years waiting on seeing what the rest of your life is going to be like.
Let's talk about cost a little bit. We had a case in Iowa recently that the gentleman reached out to us and just kind of told us what was going on. And I mean, within a few days, you're talking tens of thousands of dollars, and months later, it's suddenly into six figures. What is typical in a self-defense case? How high can these expenses go, and what can you save by being involved in somebody like FLP?
Yeah, costs are exceptionally expensive. There's typically two ways that attorneys are going to charge you. You're going to see flat fee attorneys, where somebody will say, "Yep, I'll represent you on this case." Typically, on a first degree murder case, if that's what I'm dealing with, my starting rate is going to be at least six figures. It's going to be at least $100,000, and we're going to talk about more depending on how much work I have to do based off of that. The other way you're going to have attorneys charge is hourly. And they're going to charge you, anywhere from $450 to $700 every time they think about your case in tenth of an hour increments until your case is completely resolved. And those charges are going to add up exceptionally quickly. The problem with billing people hourly is it's a little bit more difficult to work out payment plans and that sort of thing. So yeah, costs are huge. I can tell you, I have done first degree murder cases, and it easily enters into the hundreds of thousands of dollars. Even if we're talking about things like felony menacing, once you start talking about trial there, well into the six figures, or five figure numbers.
Have you had anybody where you've had a case where they've used pepper spray and needed legal assistance?
Yeah, I have. Honestly, most of the times where I've seen pepper spray cases and wind up getting charged, it is young women that carry around pepper spray as a means of defending themselves. And oftentimes you will have a drunk, aggressive male that they feel is going to sexually assault them. They wind up pepper spraying. And sometimes law enforcement gets it right and decides they're not going to file charges. Other times they look at it and say she overreacted, and they file charges against them. So yeah, I absolutely have seen those cases.
It's a good thing with pepper spray. Once it wears off, there's no permanent harm there. So we still encourage folks to use that as an option, especially if you're not comfortable with carrying a firearm. Let's talk just what are the main mistakes that you've seen in these kind of cases, where you can kind of just list some things for people to have in their mind and maybe kind of train their mind along those lines.
Yeah. So the main thing is simply giving statements without talking to an attorney first. As I said, your mind is going to be racing 1,000 miles an hour and your mouth can only move 100. And the biggest problem that I see with people when they make statements to law enforcement is they make assumptions. It is very difficult if somebody asks you a question and you don't know what the answer to it is. And a lot of people have a hard time saying, "I don't know." So when they get asked that question, how did this person break into your home? And you have no idea. You simply heard a noise downstairs. You walked down from your bedroom. You shot the guy in the living room, and they ask you, how did he break into the house? And you just say, he must have come in through the basement. Well, there's no problem in the basement, but it turns out he broke in the side door to the garage. Now, all of a sudden, you've created a problem because your statement is he broke in through the garage and through the basement, and the law enforcement's investigating. They see he came in through the garage. Now there's a discrepancy, and that's creating the presumption there's something you're lying, there's something you're hiding about. That is the biggest problem. People need to have the confidence to say, I don't know. And that's really something that I hit hard with my clients whenever we're talking about criminal cases.
So you signed on with FLP. I'm not asking you to put on a sales hat now, but just why is it important, whether they choose FLP or some other program people feel is right for them? We obviously choose FLP because we've looked at them all and feel this is a very strong contender. Why is it so important that ahead of time that they have this in place?
Well, a couple of reasons. One, being able to call up something like the hotline and being able to get put through to an attorney at any time of the day, that's absolutely invaluable. I know in my area, I know every criminal defense attorney around here, and we don't answer random calls at 2 a.m. because unfortunately we've had clients that get our phone numbers and will call us at 2 a.m. With some stupid drunk question. So being able to get through to someone is extremely important. And even if you've got your lawyer all picked out, exactly who you want to go to trial with, that doesn't mean that you're going to be able to get through to them quickly when you need to. The other important thing about it is because you have that legal protection, because that somebody is going to be, FLP is going to be paying for the services of the attorney that's helping you out, there's really no incentive to not call when you need help. There's more of a thought that, well, if this is going to cost me $7,000, $8,000, $10,000 to go hire an attorney on this case, I don't want to go hire an attorney. I'm just going to try to do this myself and save myself the money. And that's the wrong approach. But having that attorney in your pocket essentially takes away all the incentive to not go out and get help when you need it.
Yeah, good advice there. And not just the expense, but the instant access is. I had just a very simple question, I don't know, like a year ago or so, and I thought, this is kind of dumb, but I'm just going to call and see what they say. And the attorney called me back through the drive-through window of Wendy's and gave me some quick advice, and not an issue. So very, very worthwhile to have that insurance and the peace of mind that goes with it. I provided it for my kids and their wives, and just knowing that they could never afford that kind of a bill if they actually have to get into a situation like this someday.
Yep, I agree wholeheartedly.
Well, we sure appreciate your time today, and hopefully you don't mind if we reach out in the future, since you're a FFL and wear a lot of hats. You'd be a good resource to provide advice from time to time. Yeah,
absolutely not. One of the things that I really enjoy doing with FLP is a lot of the national questions even that get forwarded over to me on, on pistol braces and NFA items. I handle a lot of those questions for FLP, and I'm always happy to talk guns with people.
All right. We appreciate that. Thank you for your time today, sir.
Thank you.